I hope you enjoyed Justin McCrary's lecture. He's the best econometrician in an American law school. Really first rate. And he's, in effect, he's the same thing. His role in the law school is the same as mine, only he's the younger person. Now, I want to point out to you a mistake in the misprint in the book where what should have been a minus was printed as a 2. So if you were puzzled by those numbers in that column, it's because they were misprinted. This is another of the travesties of the system of publication we have in the United States. I told them about that mistake a year ago, and it's still in the books that are being sold to you. If this were online electronically and I could give you the book for free, this error would not be there. Okay. Now, we're treating property as a bundle of rights. Right? And a right gives the owner the power to decide. He can either do or not do the thing over which he has a right. So he can sell or not sell his property. He can develop or not develop his property. He can lease or not lease his property, and so on. Now, when you have a right like that, when you have a property right, which is a right to do something or not to do something, it's up to you. When you have that right, it needs to be protected. And there are different forms of protection. Now, the right needs to be protected against an infringement. And when we talk about the infringement of a property right, we often call it a trespass. So, for example, you have the right to exclude someone from your property, and if they enter your property, they're trespassing. If someone accidentally or deliberately builds their garage 2 feet across the property line onto your property, so that 90% of the garage is on their property and 10% is on your property, that's also called a trespass. Sometimes this word is used with respect to intellectual property. Intellectual property refers to especially patents and copyright. And sometimes if your copyright or your patent is violated, it's called an infringement, and sometimes an infringement is referred to as a trespass. So when I use the word trespass, I'm talking about someone violating your right as a property owner. Well, when you have a right, it needs to be protected. And the protection in property law consists of a remedy. A remedy that you can obtain through a court, through a lawsuit. In connection with Chapter 3, I distinguish between private law and public law, and I explained to you that in private law, the plaintiff and the defendant are usually both private persons. One of them is not the government, as in a criminal suit, where the prosecutor is the state. So in property law, you have a private remedy for the violation of your rights. And that remedy is to go to court and sue the other party. Now, when you sue, there are 2 broad classes of remedies. Remedies fall into 2 broad classes. And one remedy is damages. And that's where you ask for money, right? And the other is an injunction. An injunction is where you ask for a court order. And a court order is an order to the party who's trespassing to stop, not to trespass anymore. So, for example, if your neighbor has built his garage 2 feet onto your property, and you sue him and you get an injunction, then he will be required to remove his garage from your property. he'll have to move it over 2 feet, or if he can't do that, he'll have to destroy it. So we have these two basic kinds of remedies, and these remedies actually have a name that goes back to the history of law. Remember, law has a lot of words in it that are a consequence of its special history. And it used to be that in England, there was not just one court where you could bring your suit. In the United States, if you have a suit to bring in property law, there's usually just one court where you can bring it, and that is the court of your state where your property is located. Now, in England, historically, there were different courts, and they gave different remedies. In one kind of court gave damages, and they were called courts of law. And the other kind of court gave injunctions, and they were called courts of equity. Now, I'm not going to go into the difference between law and equity much here, because in the United States, the same court gives either remedy, can give either remedy. But that wasn't true historically, so sometimes an injunction is referred to as an equitable remedy because it was given by the courts of equity, and damages are sometimes referred to as a legal remedy. And if you go to law school, you'll learn some of the subtleties about the differences between these two kinds of remedies that have to do with their historical origins. Now, suppose that someone has been trespassing on your property in order to cut wood. They've come onto your property without your permission and cut wood on your property and removed it. In that case, what would be the difference between an injunction and a remedy? You actually want to seek both. You'd ask for both remedies. Why? Can you see why you'd ask for both remedies? Yes?
Damages would be to pay for the wood that they took, and an injunction would be to stop them from going on your property.
Exactly. So in property law, you often seek both, and you seek damages for past harm, and you seek an injunction against future harm. All right? Now you can see, suppose that the court said, well, you can have damages, but you can't have injunction, then what would be the consequences of that in the future? You wouldn't be able to stop them, but you could sue them again. So the problem is, if they won't give you an injunction against future trespass, then you have to go back repeatedly for your suit. Right? There's another difference too, which is that if you seek damages, the damages they're going to give you are usually the market value. And the market value may not be the same as the value that you place on what was taken. I had this happen in my family. We had some property in the mountains, and we had a nice hickory tree on it that we particularly loved because our property in the mountains had been pasture 25 years earlier, and as a consequence, all the trees were immature except for this one beautiful hickory, and somebody came in and cut it down. So as a consequence, we could seek money damages for the market value of the hickory, but it was hard to ask for the damages that would have been greater than that, which corresponded to the aesthetic value of the tree to us. That's the nice thing about an injunction. If you have special value that you place upon something, it's protected by the injunctive remedy, because with the injunctive remedy, the thing that you value can't be taken from you except with your consent. You have to agree to it. All right, I'll come back to that. That turns out to be an important point. Now, injunction is sometimes called the remedy in property law because it's a special characteristic of property rights that other kinds of rights don't have. For example, in tort law or in contract law, you get damages, but you don't get an injunction against future trespass because there wasn't a trespass. There was something else. There was breach of a contract. I don't know what an injunction against future breaches of a contract would be exactly. Sometimes you get injunctive remedies in contract law. The law is all very complicated. However, if you get in an automobile accident, if somebody breaches a contract, usually what you're going to get from them is damages there's not going to be an injunction for you to ask for. Whereas with trespass, there usually is an injunction against future harm. So some people will say, well, the special remedy that's available to you in property law is injunction. And the usual remedy in these other areas is damages. And that's one of the ways that property is different from contracts. Well, that's interesting. It's interesting. But what difference does it really make whether the remedy is contracts or injunction? What difference does it really make in light of the Coase theorem? Because what does the Coase theorem say? According to the Coase theorem, what difference is it going to make whether your property right is protected by a damage remedy or an injunctive remedy? Yes?
It just seems that if you don't offer an injunction,
Yeah?
it's inefficient to keep just providing damages, whereas the injunction will just stop all situations.
Well, one of the arguments is that an injunction against future harms is going to be more efficient than repeatedly litigating for damages. That's right. But that is to say the transactions cost is going to be lower. But what does the Coase theorem say? Yes. They can bargain to the same result. So if there's a threat of future trespass, suppose that there's someone who cuts across your property every day to get to work. And they don't have a right to do it, they just do it. Well, suppose you get an injunction against them trespassing across your property to get to work in the future. Well, does that mean that they're not going to trespass they're not going to cross your property in the future to get to work? No, it doesn't necessarily mean that. What it means is that if you bargain with them, your threat against them is going to be this. Either you pay me something so that I agree to let you walk across my property, or you can't cross it. Whereas if the remedy were damages, the discussion would be different. The discussion would be either you agree to pay me to let you cross my property, or else every time you cross, I'm going to sue you and get damages. Now, you don't have to be a genius to see which one is going to put the property owner in a stronger bargaining position, right? And that's the whole point of the next example, which we're going to work out in detail. According to the Coase theorem, it's not going to matter to efficiency which remedy you have if transactions costs are low enough. It's not going to matter to efficiency. It's going to matter to distribution, but not efficiency. However, according to the normative Coase theorem, you should look to the remedy that's going to reduce transactions cost. All right, so let's see how this works out in the concrete case of the electric company and the laundry. So what you'd imagine is this. There's this laundry, and there's this electric company. And the electric company's smoke dirties the wash at the laundry. And furthermore, the laundry and the electric company are not in Los Angeles. They're out in the desert somewhere where there's nothing else around. That's because in economics we try to keep examples simple. So we start with a two-party example. There's only one polluter, the electric company, and there's only one pollutee, the laundry. And what we want to look at is what difference it's going to make to their behavior with respect to the abatement of that pollution, depending upon whether the laundry has no legal right to a remedy or it has a right to an injunctive remedy, or it has a right to a damage remedy. That's what we want to figure out. Well, let's begin by characterizing what the numbers are that describe the consequences without taking into account any kind of legal action yet. We're not going to talk about damages or payments between the parties. We're not going to talk about bargains. We're talking about what would happen if they didn't have some agreement or they didn't have a suit. And since we are trying to keep this really simple, naturally, what we want is a 2-by-2 table in which the laundry can either do something to protect itself against pollution or not do anything to protect itself against pollution. And what the laundry can do to protect itself against pollution is to put filters on the windows. Put filters on the windows. So 2 cells of the table are going to be no filter and filter. This is all on page 97. Now, similarly, the electric company is going to have 2 remedies. Excuse me. It's going to have 1 remedy that it can take or not take. It's going to have 2 actions. One of them is to abate pollution, one of them is not. And the way it abates pollution is to put scrubbers on its smokestacks. So it can either have no scrubbers or it can have scrubbers. So now we have our 2-by-2 table. And we want to put the payoffs to the parties into the table where we're describing the payoffs that apply before there's any legal action taken. Before there's any suit, there's any bargain, there's anything like that. So if there are no scrubbers that are installed, that's clearly going to be cheaper for the electric company to install in scrubbers. So what we want to ask, how much does the electric company earn when it doesn't have to spend on scrubbers? And we'll make that 1,000. So the electric company earns 1,000 if it doesn't have to pay anything to abate. Now, let's ask the symmetrical question about the laundry, which is this. How much profit does the laundry earn from its activities if it does not suffer any pollution from the electric company and it doesn't have to pay to install filters? If the laundry company, as it were left alone and not harmed by the electric company, what would its profits be? Well, the answer is we need to sell where there's no filter. The laundry is not spending money on filters, and we want the electric company to spend money on scrubbers to prevent the harm. So we'll take this, put the number in this cell, and we'll call it 300. So if the laundry is not molested by the smoke, if there's no pollution, the laundry earns 300. Okay, now, what is the cost of installing scrubbers to prevent the smoke from polluting the laundry? Well, let's say that the cost of scrubbers is $500. So that if scrubbers are installed, the electric company's profits will fall from $1,000 to $500. So if we're in this cell where there's scrubbers but no filters, then the electric company earns $500. All right, what about filters? How much do filters cost? Well, here we're assuming that, to make it really simple, that scrubbers are completely efficient. They eliminate all the pollution. And filters are also efficient. They eliminate all the pollution. There's no harm to the laundry if there's a filter. If there's filters, and there's no harm if there's scrubbers. But the filters and scrubbers cost different amounts. The scrubbers cost $500. How much do the filters cost? Well, let's assume that the filters cost $200. So as a consequence, if the No, I want them to cost 100. I want if the filter is installed and there's no scrubbers attached, then the laundry has to pay for the filter, and that reduces its profits from 300 to 200. That means that the filter must be costing it 100. All right. Well, if the electric company installs the filter and if the laundry installs the filter and the electric company installs no scrubbers, then the electric company gets 1,000. Right? If the parties install both filters and scrubbers, that's a complete waste. Right? It's duplicative. You didn't need them both. I mean, if you were to do that, then the profits of the laundry would be 200, and the profits of the electric company would be 500. But this cell, we assume, this is irrational. We assume this is not, they're not going to end up in this situation. Okay, so now we've characterized the relationship between the profits of the laundry, the profits of the electric company, and the remedy that they take to deal with that pollution. Right? Now we have to look to the law and ask ourselves, what's going to happen under different legal rules? Well, there are 3 simple legal rules to be considered. One legal rule is what we'll call polluter's rights. And under polluter's rights, clearly what that means is that the polluter has the right to pollute, and the laundry has no right to a remedy. Laundry has no right to a remedy at all. So if there were polluter's rights and the parties were to if the rule is polluter's rights and the parties did not cooperate or bargain together, that would mean that the electric company would install no scrubbers, and the laundry would then have to decide whether it should, in fact, install filters. If it doesn't install filters, it's going to suffer the full force of the pollution, which is going to reduce its profits from 300 to 200. So as a consequence, if there's a regime of polluter's rights, the electric company, and yes, 100, thank you, 100. It's the pollution is the damage, the uncorrected damage is 200. The profits before the damage is 300. So the net is 100. But if the filters are installed, then the cost of the filters is 100, and you get back to the situation where the laundry was earning 300. So in that case, the laundry earns 200, and those are these 2 numbers. Right, so if there's polluter's rights and the parties can't cooperate with each other, if there's no cooperation, then in that case, the electric company is going to not install scrubbers, and the laundry is going to have a choice. It can either not install filters and get profits of 100, or it can install filters and get profits of 200. Obviously, this is more profitable. So if we have a regime of polluter's rights and the parties cannot cooperate, then we're going to have a payoff of 1,000 to the electric company and 200 to the laundry. So polluter's rights. Got to get this in here. Non-cooperation. The parties don't bargain and cooperate together, then the electric company earns 1,000 and the laundry earns 200. All right, that's polluters' rights. Now, we have two forms of pollutees' rights. Pollutees' rights either protected by damages or else pollutees' rights protected by an injunction. Let's do damages first. Suppose that the remedy is damages and the parties can't cooperate with each other. They can't cooperate with each other. So what does that mean? That means that since they can't cooperate with each other, the laundry is not going to install filters. There's no reason to install filters because it's going to get either it's going to get 300 from the market sale of the laundry because the electric company has installed scrubbers. That is to say, if the electric company installs scrubbers, it's going to get 300 just from selling the unharmed laundry in the market. Or else the electric company is not going to install scrubbers. And in that case, the laundry is going to get 100 from the sale of the laundry, and it's going to get 200 in damages. It's got to get 200 in damages because the damages have got to put it in the same position that it would have been in if it hadn't been harmed by the electric company. If it hadn't been harmed by the electric company, it would have been in this position right here. It would have earned 300, what it earns when the scrubbers are installed. So as a consequence, if there is a right to be free from pollution if the pollutee has that right, and the parties can't cooperate together, then the laundry is going to earn 300, and it's either going to earn 300 because the electric company has installed scrubbers and there's no damage to the laundry, or else the electric company has not installed scrubbers, but it's paid for the damage to the laundry. Now, which one is the electric company going to do? If you know the answer to this, you're following this. If you don't, you're not. Which one's the electric company going to do? Yes, sir. Pay for the damages, exactly, because? Yeah, well, because it'll be cheaper, right? Because how much do the scrubbers cost? 500, right? Without the scrubbers, he makes 1,000. With the scrubbers, he makes 500. The scrubbers are costing him 500. If he has to pay damages, he has to pay the difference between these two numbers, right? Between what the laundry earned given the pollution, which was 100, and what it would have earned without the pollution, which was 300. That means what he's going to pay in damages is 200, right? Well, would he rather pay 500 for the scrubbers or 200 in damages? He's going to pay the 200 in damages, right? We know that. So as a consequence, he's going to earn 1,000, and then he's going to subtract out of that 200 that he pays in damages, and he's going to end up with 800. Okay, now, what about the third legal regime, which is pollutees' rights, but they're protected by an injunction? They're not protected by damages. Well, let's assume the parties can't cooperate with each other, what we've been discussing so far. And when we say they can't cooperate with each other, I mean they can't bargain together and settle this. They have to rely on the courts to give them a settlement. Suppose we have that situation. Then we have pollutees' rights protected by an injunction. Well, if the pollutee's rights are protected by an injunction, that means that the pollutee is going to go into court and get an order for the electric company to install the scrubbers. And when that order is executed, the scrubbers will be installed and the laundry will earn $300 and the electric company will earn $500. Right? So the payoffs are $500 and $300. All right, now that's if they don't cooperate. That's if they don't cooperate. Now, which outcome is the efficient outcome? What? Polluters. Okay. Polluters' rights because sum of the two outcomes is greater. Right. If we add them together, we get the joint payoff. And as you can see, this is the larger number. 1,200 is the larger number. So because that's the larger number, that's the most efficient outcome. And remember the rule for thinking clearly about this with respect to the rancher and the farmer. Remember how we found what the joint outcome would be? We asked ourselves, suppose they got married and merged their books. Suppose the laundry and the electric company's owners married and they combined their operations. Then in that case, they would do what's most efficient. What's most efficient is to maximize their joint profits. Their joint profits are maximized when they're in this cell, and their joint payoffs are 1,200. So without any law, if the law were not in place protecting the pollutees' rights, and they got married and they joined their books, then what they do is they'd install the filters anyway to maximize their joint profits. But they would not install the scrubbers. That's because when you install the filters, it costs you 100 and you get 200 back. You get a gain of 200 in the reduction in harm to the pollution, from the pollution. Whereas with the scrubbers, it costs you 500 to get the pollution eliminated. Okay, so what we know then is that the best outcome, the outcome they would reach if they joined their books, is also the outcome they would reach if they bargained together successfully, even if they didn't marry each other, even if they didn't like each other. If they were just rational and they bargained together successfully, then they'd get to this cell. This is the cell they'd get to. So what we have to then ask ourselves is, if they get to this cell, there's going to be a surplus created by cooperating. How large is that surplus? And how is it going to be distributed between them? So let's put another column here which gives the surplus from cooperating. Now here, they're already in the efficient situation, right? Without cooperating. They don't have to cooperate with each other if the law is polluters' rights, because if the law is polluters' rights without cooperation, the electric company will not install the scrubbers, and the laundry will install the filters. So as a consequence, what is the surplus from cooperating together? Well, they can't do any better than when they're not cooperating together, right? So there's no surplus at all. There's no gain from cooperating together. There's no point in bargaining with each other. There's nothing to bargain over. But what about if the remedy is pollutees' rights protected by damages? Well, in that case, if they don't cooperate together, they get a payoff of 1,100 instead of cooperating together and getting 1,200. So as a consequence, there's a surplus, which is the difference between the sum of this, 1,100, and the sum of that, 1,200. That surplus is 100, and that's available to them to distribute if they bargain successfully to an agreement. Well, let's determine how much each one would get if they bargained to an agreement. How much would the electric company get? How much would the laundry get if they cooperate and they bargain. How much will each one get? Well, I explained to you the Nash bargaining solution, and what's the formula for the Nash bargaining solution? How much does each one get? 50% of the surplus, which is then added to what? Threat value. Each one gets its threat value plus an equal share of the surplus. That you've got to know cold. Right, that you've got to know. So the threat value for the electric company is 800, and it gets half the surplus, so it gets 850. The threat value of the laundry is 300, and it gets half the surplus, so it gets 350. So now, if we sum these together, we get 1,200. We get the efficient result. And the Nash bargaining solution has told us how that surplus from cooperating is going to be divided between the two parties. What about an injunction? Suppose the legal regime is pollutees' rights protected by an injunction. Well, in that case, if they don't cooperate, the electric company is going to install the scrubbers. The laundry is not going to install the filters, and they're only going to earn 800. Whereas if they cooperated together, they would earn 1,200. So that means there's a surplus of 400 to be had by cooperating together. And how much should each get if they're reasonable and they follow the Nash bargaining solution? Each one should get half of the 400, right? Add to their threat points, which is what they can get on their own. So 500 plus half of 400, that's 700 for the electric company, and 300 plus 200 is 500 for the laundry. So what the Coase theorem says is this: it's not going to matter to efficiency whether the rule of law is pollutees' rights protected by a damage remedy or pollutees' rights protected by an injunction. It's not going to matter because they're going to bargain together, and when they bargain together, the sum of their payoffs is going to be 1,200. It's going to be the efficient result. However, the distribution of that amount of money is going to be different depending upon the threat values of the parties, depending upon the rights that they have. Now, if you were the laundry, would you rather have your right to be free from pollution protected by the damage remedy or protected by the injunction remedy? Injunction remedy, right? Because you'd rather have 500 than 350. So the injunctive remedy gives you more. Where does that more come from? That more comes from the fact that you can threaten the electric company with having to bear the full cost of installing the scrubbers, which is inefficient. It's 500, it's inefficient, shouldn't install them. But you have the power to make them do it. So because you have the right to an injunction, if that's the remedy, you're in a stronger bargaining position. Which follows exactly our intuition about the person who's crossing your property to get to work. And he's trespassing, and you threaten him, and you say, look, you're going to have to pay me something if you want to cross my property every day to get to work. And you bargain together, and you're in a stronger position if you can exclude him, if you can get an injunction to exclude him from crossing your property, than if you have to go back and sue him every time he does it for the harm that he caused. Okay, now I got this result here. that the pollutee is in a stronger bargaining position, gets more of the surplus from cooperation if his right is protected by an injunction remedy. And I got the result that his position is weaker, but still pretty good if he has a right that's protected by a damage remedy, and he's in the worst position is if he has no right at all. Right? Yes?
If we change the payoff structure, for example, we put scrubbers and we say 900,
Yeah.
only 100 we sell scrubbers, so it's 900, 300 scrubbers, and no filter part. Will this example develop completely hold?
That's exactly the right question, which is exactly what I'm getting to. If it cost less to install scrubbers than to install filters, then this would be the efficient cell. And that is the cell that you would get to if there were pollutees' rights rather than polluters' rights. They would, if there were polluters' rights, they would bargain to the efficient cell. Okay? Which, if we change the numbers, is the efficient cell is the one where the solution to pollution is to install scrubbers rather than to install filters. So that aspect of the problem depends on this particular choice of numbers. It is not generally true that injunction is a more efficient remedy than damages. It's not generally true that doing the action that's required for to eliminate the harm by the injurer is more efficient than doing the action to eliminate the harm by the victim. Okay? Now there is something else though that's constant in this. You look puzzled. You understand what I'm saying?
Yeah, I'm following.
Okay, yeah. Go ahead. Sir?
Since you're reaching at 1200 on all three,
Yeah.
does that mean it's more efficient?
It means that the Coase theorem says that if the parties can cooperate together, you'll get an efficient result regardless of the distribution of the underlying right. So that's that. If they can cooperate together, if there's no transactions costs that prevent them from cooperating together, then all three are equally efficient, which is exactly the Coase theorem. But the distribution effects are different. Yes. And what I say is this. In this example, it's an accident of the numbers that it's cheaper to eliminate the pollution by using filters rather than scrubbers. Right? It's cheaper by... if it were the case that it was cheaper to eliminate the pollution by installing scrubbers rather than filters, then in that case, if the parties could cooperate together, that's where they'd always end up. They'd always end up where the scrubbers were installed, but not the filters. But if the parties couldn't cooperate together, and the polluter had the right to pollute, then in that case, what would happen is the polluter would not install the scrubber, and the laundry would have to install the filter. Right? We'd be in this cell again, no scrubbers and filters, but now this cell has become inefficient. It's become inefficient because the cost of the filters now are higher than the cost of the scrubbers. Okay? Yes? Yes. Well, that's a very good question. And you remember when I explained the Coase theorem, and I said, suppose they got married and all that. I said, one of the reasons you want to focus on that is because you can think of a lot of reasons that might be exceptions to this result. But if you focus on the fact that what would they do if they got married, then you see the full generality of the result. Because the answer is, you can put in long run and short run, and you can put in fixed cost of investment up front and variable cost. You can make the problem much more complicated. But it's still going to be the case that if they were to get married and combine their books, they do the most efficient thing. And it would still be the case that if transactions costs are zero, rational people are going to get to that result through a bargain even if they don't get married. So that's why I like the marriage example, because it makes it clear that things like these complications you're raising do not go to the fundamental issue. The fundamental issue is, can you bargain together or can't you bargain together? And that, in COSIS terms, is a question of transactions costs. Anybody else have a question? Okay, now, what I've shown is that from the polluter's advantage, polluter's rights is best. Pollutee's rights protected by damages is second best. And pollutee's rights protected by an injunction is third best. Conversely, from the point of view of the pollutee, it's the opposite is the case. The injunction is best, damages is second best, pollutee's rights is third best. So we have this definite ordering as to which rule of law you'd prefer, depending upon whether you're the polluter or the pollutee. Now the question is this: is that ordering an accident of the numbers? Would the pollutee always prefer to have an injunctive remedy? And would the polluter always prefer not to have an injunctive remedy, but to have a damage remedy, or even better, have no obligation? That's the question. And there's a simple reason why this injunctive remedy is always better for the victim, and the damage remedy is always better for the injurer. Can anybody see what it is? Yes. Yes, that's right, but I want you to express it a little bit differently. You're very close. You have a,
If it's not worth the cost, then the polluter can always decide to not do it anyway.
well, that's basically right. The point is that if the polluter has to pay damages, he's got a choice. He can either pay damages, or he can eliminate the pollution, in which case he has no damages that he pays. So he can do whichever one is cheaper. He can do, if damages is cheaper, he pollutes, he pays damages. If the scrubbers are cheaper, he installs the scrubbers, he doesn't owe damages. So the damage remedy gives the polluter a choice. And he can't be made worse off by having the additional choice. He's either definitely better off or he's no worse off. But he's never worse off for having the additional choice. So the polluter would always prefer that the pollutee's rights, if the polluter must have a right, that it be protected by damages rather than an injunction. And the opposite is true of the pollutee. The pollutee would always prefer that the polluter didn't have a choice, because if the polluter doesn't have a choice, that puts the pollutee in at least as strong a bargaining position. His bargaining position can't be weaker, and it's often going to be stronger. So the basic point is that the damage remedy gives the injurer a choice between stopping the harm or paying the damages, and the injunctive remedy does not. Yes? Well, I think that's a very nice question, a very nice remark. Now let's get everybody into the conversation so you understand what cap and trade is. Cap and trade is a system whereby the total pollution from a certain industry or in a certain region, the total pollution somehow defined, like, say, particulate emissions in the Los Angeles basin by factories, particulate emissions in the Los Angeles basin by factory is capped, and you can't emit any more. What you can do is you can trade your rights to emit what you have the right to emit, okay? So usually what you do is you take some base year and you say whatever people were emitting in that year, they have the right to go on emitting that amount. But they can also trade. So if you want to emit more pollution than you've been emitting, then under cap and trade, what you have to do is you have to pay somebody else to sell you the right to emit more, which means they're going to have to emit less, right? So you're holding the total quantity of pollution constant. And at the same time, by trading the right to emit, you're reducing the cost of meeting that pollution goal. And furthermore, you can gradually clean up the air in the most efficient way by reducing the value of those pollution rights that were initially given to people, okay? Initially, what you get is you get to emit 100% of the pollution that you were emitting in 2012. But then in 2013, you're only going to, each of those pollution rights, each of those rights that permits you to emit as much as you've been emitting, is going to be reduced by 10%. And then it's going to be reduced by 10% again, and then by 10% again, so you ratchet it down. But the whole time you let people trade so that the cheapest party to avoid the pollution is the one who undertakes it. So what would cap and trade mean in this context? Well, if you gave the electric company the right to emit the pollution that it's emitting when it has no scrubbers, you're already at the efficient solution and there's going to be no change. If it should turn out, as this gentleman proposed, that scrubbers were in fact cheaper than filters, if we reverse the numbers, and you gave the No, I'm going to shut up. This is getting too complicated. The point is this. By getting people to trade pollution rights, you can save a lot of money in abatement costs and get to the same goal. And economists all favor a scheme like that. Economists, almost 100%, favor either marketable pollution rights in common pollution, not in forms that are super dangerous, not like radioactivity or something like that, but particulate matter, CO2 demand in water. Well, common pollutants, almost all economists think you should have markets to buy and sell the right to pollute, or else you should have a tax on the amount that you pollute. If I had time, I could explain to you why those are virtually the same thing, except for who gets the money, whether the government gets the money or whether the polluters get the money. I could explain. There's a lot to understand here, and this is kind of a foundation for it. But I'm not going to talk about that anymore now, because that's all about public law. It's about setting up a public system of administration in which you cap, in which you allow the trades to take place, and it's really important. It's particularly important if you're an environmentalist. When I first arrived in Berkeley, the environmental movement hadn't appreciated the basic facts of economics with respect to pollution. And the Environmental Defense Fund, which mostly sues polluters, or it sues the government to follow its own rules, an organization that I considerably admire, which is located here in Berkeley. The Environmental Defense Fund was against cap and trade. It was against marketable pollution rights. It was against pollution taxes. And they had really stupid emotional arguments about it. They said things like, well, why should you have to pay people to stop dumping trash in your backyard? Well, okay, yeah, but we got this problem with pollution, you see, and we got to deal with it. And we got to deal with it in a way that's cheap. And if you care about the environment, you want abatement to be cheap, because then you're going to get a lot more of it. And cap and trade makes abatement a lot cheaper. Now we have this stupid movement in the country right now against cap and trade again. It's come back. I don't have time to go through it, but economists think that's politics. It's not good economics. Yes?
I was going to say, cap and trade is not all that. I was reading an article, I don't remember exactly, they were saying that because you can sell certain kinds of pollution gas or whatever, some countries and companies are actually emitting that pollution gas, or creating that pollution gas, but in doing so, they're creating other kind of substance that harms the environment. They just sell that pollution gas to make money.
Yeah, I know. This has been much in the news. The point is there are these gases that were used in old refrigerators that are a little bit cheaper than the ones that are used in new refrigerators, but they're very, very damaging to the environment. And what we got was an international agreement to cap the amount of that kind of pollution and then reduce it over time. And the system of administration across countries was not well thought out, and it wasn't provided for in the proper way. And as a consequence, there are ways of gaming this system. There are ways of gaming this system by basically producing more of this. What you do is you produce more of this gas, but then you don't emit it in the air. You sell it to somebody else to clean it up, and you can make money by doing that. Well, that's just a stupid rule. That's not inherently something wrong with cap and trade. It's wrong. It's a rule that was poorly designed without considering the actual incentive effects it was going to create. Cap and trade doesn't necessarily produce that result. That's just an accident of an unfortunate international arrangement that needs to be changed. Now, this points out a very grave problem that we have in the world, which is that the pollution, a lot of the pollution that's emitted harms the planet, and the costs of abating it fall on the particular country where the pollution is being emitted. So in America, we're becoming a lot greener than we were. But at the same time, the atmosphere is getting worse because China and India have industrialized, and they're overtaking the United States as a polluter. And this is a really difficult problem because everybody wants other people to clean up the pollution, but not to have to do it yourself. We have a very difficult international problem with cleaning up pollution. But that's not private law, so I got to get back to this stuff. Okay. All right. So, I want you to work through this example, and I want you to make sure you can get the numbers, right? You start with table 4.4, the table that gives these numbers before there's legal action, and then without looking at table 4.5, you reproduce it. You need to be able to do that. All right? 4.5 is these numbers here, showing the cooperative and non-cooperative results according to the background rule of law. All right. Now, one of the characteristics of this example is that there were only two parties, the electric company and the laundry, somewhere way out in the desert where no one else is being harmed. And what we found is we get efficient results regardless of whether it's polluters' rights or pollutees' rights. But the distribution of the surplus from cooperation is different depending upon whether the remedy is injunction or damages. So this example illustrates the Coase theorem, that the underlying rule of law doesn't matter to efficiency as long as there are low transactions costs. Now, suppose that we were not talking about an electric company and a laundry out in the desert. Suppose we were talking about a laundry and electric company in Los Angeles. where there's a lot of laundries and a lot of electricity generators. Indeed, suppose we weren't even talking about the laundry and the electric company. Suppose we were talking about motorists driving their cars and people having to breathe the pollution from their cars. Is the Coase theorem going to be true? Is it still going to be true that the underlying rule of law doesn't matter from the point of view of efficiency?
Duh.
No, obviously not. It's one thing to say, if the laundry and electric companies sit down at a table and bargain together, the costs of their doing so are not very high. They're contiguous landowners. In most property disputes involve contiguous landowners. Contiguity just means their properties touch each other. And when your properties don't touch, many property disputes don't spill over. They only spill over to contiguous landowners. And they involve small numbers who can sit around a table and bargain. But it would take a pretty big table to get all the commuters in Los Angeles sitting around it, wouldn't it? And the cost of bargaining together there would be enormous. So as a consequence, the Coase theorem remains true in Los Angeles. It's just that the condition that transactions costs are zero doesn't apply. Transactions costs are enormous. So when you get large numbers of people interfering with each other, of property owners that are not contiguous interfering with each other, like the guy who owns the property where the electric company is and the guy who owns the property where the laundry is, when you get a lot of them interfering with each other, then what you're going to get is you're going to get the non-cooperative solution. The parties are not going to be able to bargain together, and as a consequence, legal rights are going to remain with the party to whom they're initially allocated by law. There's not going to be a bargain to switch them around. So if we have polluters' rights, then the polluters are going to pollute. And the pollutees are not going to be able to organize themselves to bargain and pay the polluters to stop polluting, even though the cost of stopping pollution is less than the harm that it causes. Yes? Well, that's a good point. As we'll find when we come to class action suits in Chapter 11, the point of a class action suit, the legal justification of it, is to solve the transactions cost problem. That is to say, if you have 5 parties who are damaged, or even worse, if you have 50,000 parties who are damaged, for them to cooperate together and launch a suit is very difficult. It may be that the suit will cost more than any one of them can recover, but the suit will cost a lot less than all of them can recover together. Right? And in those circumstances, the law provides for a class action, which means that the court can certify a lawyer and a plaintiff as representatives of the entire class of victims. That solves the transactions cost problem, right? Now this here we need to introduce another piece of language here, which is the free rider. The free rider, the way to think of the free rider is this. When I was a youth in London, I used to stay in cheap hotels where you didn't get heat unless you put a shilling in a little meter. Put a shilling in a little meter and then go tick, 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 and when it stopped ticking, you froze in the dark again. So that was the way I got heat in those cheap hotels. Now imagine that you've gone to the beach and you've taken an old-fashioned trolley. You're in, I don't know, in The Hague, where you might take the trolley to the beach. So you get on the trolley and you go to the beach and you have a good time, and then you get back on the trolley, and it turns out that they've changed the way they collect the fares. And the way they collect the fares is they've taken that same meter that I had in that hotel in London and they put it in the trolley. And a trolley won't move until somebody puts a euro into the meter. And at that point, the trolley will go down the tracks 1 meter's worth, and then one euro's worth, and then it'll stop. Now, it may well be that you have 50 people on the trolley, and all of them, each of them, would be happy to pay more than a euro to get back to town, to get back to The Hague. So you could collect more than 50 euros from them and give them a ride, and they'd all be better off. However, when they get on the trolley, they realize it only costs, say, 15 euros. You only need 15 euros put in the meter, and you'll get back to town. So everybody sits there and waits for somebody else to put the euros in, right? That's the free rider problem. Everybody wants the free ride. Let somebody else put the euros in the meter. So as a consequence, the trolley doesn't go anywhere. That's the free rider problem, and it's quite pervasive. Its characteristic is that there's some public good, a good that it benefits a public rather than just an individual. In this case, the public is everybody on the trolley. The good benefits everybody on the trolley, regardless of whether or not you contributed. Regardless of whether or not you put a euro into the meter, you still get the ride. And the free rider problem in general obstructs the production of public goods. So, yes?
So the efficient way to solve this maybe is split it so the 15 among all those 15 would be like 30 cents each.
The efficient way to do it is to any way you can that raises 15 euros and pays for the cost of the electricity to get it back to town. Efficiency doesn't have to do with how that cost is distributed.
So they make
It would be equally efficient. The distribution effects would be different. I mean, you might say the fair thing to do is for everybody to pay an equal share. Yeah, it probably is. How do you make them do it? Yes. Intellectual property law. It is certainly prevalent in intellectual property law. Give us the class an example of what you have in mind.
Like, say, for example, a patent expires,
Mm-hmm.
and we don't find it, like copyright maybe, like
Mhm.
very infringement, but then how do you define infringement, like, if, say, it's for a educational purpose, but then the author considers it infringement?
All right. Well, let me help you out. We're getting ahead a little bit because I'm going to be talking about intellectual property probably in the next class. But there is this basic characteristic of ideas which is different from material goods. And that's this. If I take a bite out of an apple, there's one less bite for you to take. But if I listen to a Beatles song, you can listen to it too. There's just as much of the song left. And that characteristic is referred to as non-rivalry. What non-rivalry means is that when one person consumes the good, there's just as much left for others. And that's a characteristic of many public goods. If you have studied your microeconomics and learned the theory of public goods, the example that's often given is military security. When I was a youth, we rationally feared a nuclear attack from the Soviet Union. And the Soviet Union rationally feared a nuclear attack from us. And in those times, you see, if a measure were taken by the Department of Defense to increase the security of the country against a nuclear attack, then everybody enjoyed that. You know, if I, standing here, were safer from a nuclear attack, then so were you. And the fact that I was safer didn't make you any less safe. It's not like eating the apple. The security was not being used up by the fact that I enjoyed it. An equal amount was available for you to enjoy. And that's why, if you learn the theory of public goods, you may well have heard military defense or security offered as the example of a public good. How many have seen that example before? Yeah, okay, that's what I figured. So, everybody on the trolley wants to free ride and let somebody else pay to get the trolley back from the beach to town. And similarly, when you have a lot of polluters and a lot of pollutees, you get a lot of free riding problems. If the victims need to bring a suit, then everybody would prefer for somebody else to bring the suit so they don't have to pay the cost. Because they know that if the solution to the suit is the protection of the pollutee's rights, they're pollutees, they're going to be protected whether they brought the suit or not. It's just like with military defense. You knew that you were going to be secure if the Defense Department did something to increase your security, regardless of whether you paid for it or not. Didn't matter whether you paid your taxes or didn't pay your taxes. You were going to be equally secure. So why not free ride if you get the chance? Same way here. Why not free ride on litigation to stop polluters? Everybody who gets the benefit is going to get it anyway. Now, free riding is in the terms of the Coase theorem, this is a very serious kind of transactions cost. The problem is the kind of bargaining that's required to overcome the free rider problem is very difficult to organize. That's part of what the government is for. Our elected representatives have the power to bargain together and enact legislation to stop pollution. And they can do it. They can solve the free rider problem in doing it because they have a majority rule system. They have a majority rule system, and when you vote, the majority controls. It's not like everybody sitting around a table and bargaining and everybody having to agree. It's when you have a unanimity rule and everybody has to agree, that's when you get the worst free rider problems in the state. And that certainly is where we get terrible free rider problems with respect to pollution. Now, I should, since I started down this road, I should complete the description of a public good, which is usually public good is said to have two attributes. One is non-rivalry. If I listen to the song, there's just as much of the song left for you to listen to. And the other is non-exclusion. And what that means is that it's very difficult to exclude people from enjoying the benefits of the public good. So in the case of military defense, if someone didn't pay his taxes, it was hard to say to him, look, if you don't pay your taxes, then we're going to let the Russians attack you. No, it didn't work that way. I mean, the Soviet Union attacked us, we all got attacked, right? Same way here. If you don't contribute to pay for the trolley, then we're going to throw you off the trolley. Well, probably you can't throw them off the trolley, right? I mean, maybe the law doesn't let you throw them off the trolley. Maybe you feel like throwing him off the trolley, but you can't throw him off the trolley. All right? And with copyright, excluding people is very difficult, as Napster proved. It's a pervasive problem. Once I have a copy of the song, what's to prevent me from giving you a copy of the song? Since there's no rivalry, it doesn't hurt me. So it's very difficult to prevent people from using the song who didn't pay for it. Exclusion's hard. So those are two attributes of public goods, and one of the characteristics of public goods is that it's difficult to provide them by markets. The problem of free riding will disrupt their provision by markets without a lot of legal intervention. Whereas the opposite is true of private goods. Private goods are ones for which there is rivalry and there is exclusion. And when there is rivalry and there is exclusion, you can organize a market and you can buy them and sell them. So here we have hit upon a very important fact about the difference between the public sector and the private sector in the economy. And that is that public goods are appropriately owned by the public. They're not privately owned. Or else they're privately owned, but it's so heavily regulated and controlled it doesn't look much like private ownership. Whereas purely private goods, where there is rivalry and exclusion, there we can have the rules of property law and markets will work quite well. That's the end of today's lecture. Next time we start on chapter 5. There is an appendix, a philosophical appendix that I urge anybody to read who's interested in such things. Hi.
I'm a little bit confused as to your math right there and how it relates to the chart.
Yeah. Okay. So if there's no filter installed and there's no pollution because there's no scrubber,
right,
then the laundry gets 300, right?
Yeah.
Right? Okay. If there is pollution, just to say there's no scrubber, and he doesn't install a filter, then of the 300 that he would have earned, 200 is destroyed, and he ends up with 100. Okay? Now he can, however, spend 100 to put filters on the windows, and if he spends 100 to put filters on the windows, he'll get back this full amount, less the 100 that he spent on the filters. That gives him 200. Okay?
So it just happens to be that it seems